possibility that vague descriptions have landed the wrong man in court today. We have proven here today that 1. There was another person in proximity of the park with an identical jacket of Sandy Meyer's. Number 2. Under the cover of precipitation and darkness, it was impossible for the prosecution's client to make a valid identification while being dizzy from struck with a lead pipe. 3. Knowing that another person was in the proximity of the park and was running away, but was never pursued, and no substantial evidence showing that the defendant was indeed the perpetrator of this crime, it is impossible to confidently declare that my client is guilty. The burden of proof is on the prosecution in a criminal case. The prosecution has failed to meet their burden of proof and has not proven beyond a reasonable doubt that the defendant is guilty. In fact, there was another person wearing a similar jacket as the defendant who was seen in the park and he was never pursued. Why wouldn't the police try to find everyone involved in a crime as to make a confident assessment as to who could have possibly committed the crime? Furthermore, the witness for the prosecution, Leslie Johnson, the victim, suffered a concussion from the attack when she went to the hospital. How, in a dizzy and disoriented state of mind that Ms. Johnson herself stated, can she correctly identify her perpetrator as he is running away from her in the rain, at night, in the dark? Furthermore, the defendant's clothing is not grounds for identification as the second suspect was wearing a similar jacket. The prosecution in this case would like you to believe that darkness, rain, a dizzy victim, and the ambiguous clothing of two suspects still constitutes a positive identification. Lee Peterson, the prosecution's third witness, testified it was difficult to see, but still said she was absolutely certain that it was the defendant who committed the crime. Now, which is it? Was it too hard to see, or did she make a positive identification? There is no physical evidence in this case, as Ms. Johnson's wallet was never recovered, the lead pipe was never recovered, and the knapsack was never recovered. Excuse me, the knapsack was recovered elsewhere. If the police searched the park as Sandy Myers was leaving it, wouldn't they have found these items? Did Sandy Myers have time to hide these items, put them in another place? The answer is not. These items should have been recovered if Sandy Myers was guilty. We are asking today that the court execute the legally just action while insufficient evidence has been presented to prove a defendant guilty and to find my client innocent.
Your Honor, this case is a case of robbery and assault. First, I would like to start off by reading the definition of an assault. It's a person is guilty of an assault in the second degree when, with an intent to cause physical injury to another person, he causes such injury to such person or to a third person by means of a deadly weapon or a dangerous instrument. Assault was clearly committed in this case. The defendant, Leslie Myers, was attacked from behind and hit with a lead pipe. We heard testimony from Leslie Myers from Leslie Johnson saying that that happened. Next, robbery. Robbery is forcible stealing. A person forcibly steals property and commits robbery when in the course of committing a larceny he uses or threatens the immediate use of physical force upon another person for the purpose of compelling the owner of such property or another person to deliver up the property or to engage in other conduct which aids in the commission of the larceny. This was also clearly done. Leslie Johnson's knapsack was stolen from her while she was on the ground after being hit. Therefore, the elements of the case are all established. Those are not up for debate. Really, the only question left is to find who did the crime, who committed it. The prosecution feels that we have proven beyond a reasonable doubt that the person who has done this crime is Sandy Myers, the defendant. We have two witnesses who placed Sandy Myers at the scene of the crime and testified that he was the person who committed the crime. Leslie Johnson was attacked by the defendant and after she was attacked, saw the defendant running away with her knapsack. Lee Peterson heard the yelling of Leslie Johnson as the defendant, Sandy Myers, was running away from her with her knapsack, and positively identified Sandy Myers as he ran underneath a streetlight. She saw him clearly and could definitely positively identify him without any doubt after he was apprehended by police later in the evening. Therefore, the prosecution feels that we have clearly shown that Sandy Myers was the culprit. The defense tried to argue that Sandy Myers did not do it, that he was running to go see his friends across the park at Lou's and then back at Houlihan's, but he was not able to corroborate his alibi. No one saw him running from the theater to Lou's. No one saw him running across the park. The cinema owner, who the defense tried to claim saw Sandy Myers in the theater after the movie was over, and therefore he could not have committed the crime. The cinema owner was not sure whether it was Sandy Myers or not. He could not be positively sure, and he was not sure if the same person that he saw sitting in the theater after the movie was over was also the person being arrested. He had no idea. He said that he thought he knew.
The phrase "he had no idea" is clearly prejudicial.
I'm going to allow it.
He said that it could possibly have been the person, but he did not know. Therefore, Sandy Myers' alibi is not valid because he could not have anyone corroborate where he was at the time. There are several minutes where Sandy Myers' whereabouts and actions cannot be accounted for. Also, when Sandy Myers ran out of the park and yelled, "Don't shoot," the defense tried to claim that he yelled that because the police had guns pointed at him and he thought he was going to be shot. However, the police officer Tucker did not have a gun drawn at the time. He had a searchlight pointed there, but there was no reason why Sandy Myers would expect to run out of the park and be shot. There was no basis for him to think that, and therefore him running out and yelling, "Don't shoot," shows that he thought that he was going to be shot because he had done something wrong. He had been chased by Leslie Johnson. She saw him and knew who he was and could possibly identify him when she returned to the police car and saw him there. She said, "You got him." She knew it was him. She could possibly identify him. Lee Peterson, same thing. He came to when he ran out of the park and Lee Peterson saw him in the streetlight. She identified him. She knew who he was and could possibly identify him without any doubt.
Objection, Your Honor. The degree of doubt in those identifications is for the jury to decide.
It's true. That part of your quote is true.
Thank you. Your Honor, what we have here before us is a simple matter of fact. Fact. Leslie Johnson was forcibly robbed and assaulted. Fact. Sandy Myers cannot account for his exact whereabouts and actions on that night. Fact. 2 separate eyewitnesses have testified that they identified the defendant as he tried to leave the park as the same person who robbed Leslie Johnson. We are confident that you will find the defendant guilty of assault in the 2nd degree and robbery.